Hi, I'm Robert Brunson. I'm a lawyer in Charleston, South Carolina. I'm co-chair of the Private Wealth Services Practice Group at Nelson Mullins, Riley, and Scarborough. The Private Wealth Services Group includes litigators in probate court in many states around the country. And today on the Will and Probate Litigator blog, I'm joined by Dr. Linda Austin in the first of a three-part series. The three-part series is focusing on undue influence and testamentary capacity and how the legal and psychiatric issues affecting an aging population interact. Dr. Austin, thank you for joining us today.
Oh, thanks for having me, Robert.
Dr. Austin, with the increasing aging baby boomer population in the United States and the large accumulation of wealth that many have, concerns are increasingly becoming present for children or the natural heirs or beneficiaries of wealthy individuals as they age, that perhaps as a result of declining mental capacity, perhaps Alzheimer's or some other form of dementia, that the estate plans that those people have put in place can become at risk, as well as their relationships with their families.
Sure.
Share with us just an overview of your, experience of how psychiatric, psychological issues interplay in those situations.
Well, Robert, we know that by age 85, about a third of people will show signs of dementia. And dementia, of course, is an umbrella term for many different sorts of diseases, of which Alzheimer's is one. And what happens in dementia can vary a lot from person to person, but I think of the bright line where you really start to have to be concerned is when your loved one begins to not be able to live independently. It's one thing to have to need somebody to be a housekeeper or help you with daily things. But when mom or dad can't even be the one, let's say, to call around or interview that housekeeper or set standards for that housekeeper, that's a real loss of independent function. And that's, I think, the sort of person who may become vulnerable to undue influence.
Now, from a legal standpoint, there are two questions that are really separate. One is, does a person have what's called testamentary capacity in order to make a will or to set up an estate plan? And a separate question entirely is whether someone is under undue influence. Describe your understanding as an expert in psychiatry of how you would evaluate somebody to determine if they have testamentary capacity.
Well, this varies from state to state. And in most states, the bar is actually rather low. So the criteria, for example, that are pretty typical in a state are the ability to know what a will is, the ability to know who your so-called natural heirs are, that is, who your, let's say, your children or grandchildren who you would expect to inherit, the ability to know what your assets are, and then the ability to come up with a coherent plan for distributing your assets.
And it's pretty hard as a lawyer to establish that an individual lacks testamentary capacity. Although those tests are not black and white, and there is some room for evaluation by expert witnesses and the court, it's still a very uphill battle to establish that when someone creates a will, they don't meet those three criteria. But an entirely separate question is whether someone is under undue influence. That's an issue that comes up typically when a wealthy individual, a man or a woman, I'm just going to use dad to simplify who we're talking about. Dad is no longer married to his original wife. He has children from prior marriage or marriages, and he is either in a relationship with someone, maybe even a caretaker, maybe even a second, third, or fourth wife, and that person tries to undo the estate planning that dad had in place where he was trying to leave his wealth to his children previously. And every marriage includes influence of one spouse over another, but the law recognizes that if estate plan changes are made as a result of undue influence, they can be set aside. Can you explain to our audience what undue influence might look like from the view of a psychiatric expert witness?
Sure. Well, there are, we call them 4 pillars that we look at. We look at the characteristics of the victim. So is that person in a state of dependency in some way? Are they vulnerable? We look at the characteristics of the so-called influencer. Is that person in a position of trust or competence? Do they have authority over the potential victim? It could be a caretaker, it could be a clergy, it could be a physician for that matter, but somebody that the often elderly person really looks up to and has come to depend on and wants to try to please. And then the third pillar that we look at is what is the nature of the interaction between the two. And there are certain characteristic things that you actually see, Robert. For example, does the influencer try to isolate the elderly person from their family? Do they start to badmouth the family members? We call that relationship poisoning. Are they reinforcing helplessness? Are they manipulating transactions in some way? Are they trying to get the person to change the deed on their house or change their will? And then a real red flag is there a firing of trusted advisors? So suddenly there's a new lawyer who's been put in place.
Thank you, Dr. Austin. This is the first of a 3-part series of blogs that I'll be doing with Dr. Linda Austin, where we're talking about estate planning issues, probate litigation issues, and wealth transfer in a day of aging baby boomers.